If you live in a caravan, van or wagon, you're a traveller, right? But two people can live almost identical mobile lifestyles and yet be treated very differently by the law. Because once you actually try to live on the road, in a caravan or outside conventional housing, the system starts behaving very differently. So who gets recognised as a traveller and who doesn't? And this is a really tricky situation. Many people seem to misunderstand. I certainly misunderstood for a long time. So let's try and put it straight. Living on the road, waterways or off-grid in the UK, Dickie Dread. Still on chapter 1, near the end of chapter 1 in fact. And it's parts 13 in the video series. So chapter 1, types of travellers and off-grid folk. Traveller status. In the UK, the word traveller can mean different things depending on the context. In everyday conversation, it may simply refer to anyone living a mobile lifestyle, people in caravans, buses, vans, wagons, boats, or other forms of temporary accommodation. In legal contexts, however, the term can have more specific meanings. Some travelling communities are recognised in law as ethnic groups with particular legal protections. Others are simply people who have chosen to live a nomadic or semi-nomadic lifestyle. Understanding the difference matters because the legal framework that applies to each group can be quite different. For the purposes of this book, the focus is not limited to any single travelling culture. Instead, the book looks at the legal and practical realities faced by anyone attempting to live on the road, on water or on land outside conventional housing in the UK, whether they identify as travellers, van lifers, vehicle dwellers, boat dwellers or something else entirely. Legal recognition. Certain travelling communities in the UK are recognised as ethnic groups under equality law. The two main groups are Romani Gypsies and Irish travellers. In England, Scotland and Wales, these communities are protected under the Equality Act 2010. In Northern Ireland, similar protections exist under the Race Relations Northern Ireland Order 1997. These laws recognise these groups as ethnic minorities and are intended to protect them from discrimination in areas such as employment, education, housing and access to services. And we talked about this a bit earlier. Despite these legal protections, many members of these communities continue to face significant prejudice and social exclusion. People who live a nomadic or semi-nomadic lifestyle are not members of recognised ethnic traveller groups, including most New Age travellers, van lifers, vehicle dwellers and boat dwellers, are not protected under the Equalities Act as ethnic groups. In legal terms, they are simply individuals who have chosen a mobile or off-grid way of life. That distinction does not make their lifestyle unlawful. It simply means that the law treats them differently when it comes to certain rights and protections. So that's the important point. This applies regardless of whether that lifestyle is based on the road or on the water or on land. Traveller status in planning law. Planning law sometimes uses a broader definition of the word traveller. For planning purposes, a traveller may be defined as someone who lives a nomadic or semi-nomadic lifestyle and uses caravans, motorhomes or other forms of mobile accommodation. This definition is mainly used when councils assess the need for traveller sites or consider planning applications involving caravans or mobile homes. A person can still be considered a traveller under planning law even if they temporarily stop travelling for reasons such as employment, education, family commitments or health issues. What matters is whether there is an underlying pattern of mobility over time. This definition can sometimes include people living in caravans or motorhomes, although it is usually applied primarily to ethnic traveller communities. It does not generally extend to people living on boats, as waterways are governed by separate legal frameworks rather than planning law. And note, there is nothing to do with 10 years or X years or anything to do with that. And we'll cover that in a little bit more detail in the next section. So traveller status isn't simply about mobility. It's about legal recognition, historical identity, and the way institutions classify people. The debate isn't only about caravans, vans, or stopping places. It's about who receives protection, accommodation, and recognition. which means the issue may not be just whether traveller sites, planning law, roads, or may not be just traveller sites, planning or mobile encampments. It might actually be who gets to live outside conventional housing and still be accepted as legitimate. So, are these laws managing mobility or deciding which forms of mobility society is willing to tolerate? So next up, we're on chapter 1. We're finishing off chapter 1 in the next. We'll get on to chapter 2. Types of travellers and off-grid folk, and we'll cover accommodation and planning, social and practical challenges. This is all for travellers. Cultural identity and advocacy, and what traveller status actually means. Now you can get the book, of course, which is available here, and just like to say thanks to Craig High for doing the cover art on this one. Cheers, mate.